Do you have a past criminal record and wondering if you could still come to Canada? Here's what you need to know. In Canada, immigration officers look at every case carefully, whether you're applying for a visa, an ETA, or entering at the border. If you've ever been charged or convicted of a crime, you may be considered criminally inadmissible. This applies to both minor and senior offenses. Things like theft, assault, DUI, drug possession, or dangerous driving. But here's the good news. Depending on how long it's been and how you've lived since then, there are ways to overcome this. You may still be allowed to enter Canada if you are deemed rehabilitated, meaning enough time has passed since your conviction, you have applied for and been approved for rehabilitation by IRCC, you were granted a record suspension, also called a pardon, or received a temporary resident permit, also known as a TRP. If you're applying for rehabilitation, you'll need to show you've changed and are unlikely to commit new offenses. At least 5 years must have passed since you completed your sentence, including probation and the act itself. These applications can take over a year, so it's important to plan early before you travel. If your offense happened in Canada, you can apply for a record suspension through the Parole Board of Canada. If it were outside Canada, check with your local visa office to confirm if your pardon is valid here. And if it's been less than 5 years since your sentence, but you have a valid reason to visit, you can apply for a temporary resident permit. An officer will review your case and decide if your reason to enter outweighs any risk. At T.Immigration, we help you navigate complex cases, including rehabilitation, TRP, and record suspension applications. If you're unsure about your status, message us at T.Immigration. We'll help you take the right legal steps towards entering Canada safely and confidently.